Hello everyone and welcome to the December 2024 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway and I'm an executive partner here at our Troy office. Today I'll be joined by my partner Jeff Willard, who will be discussing the trending topics in PIP litigation portion of our December episode. But for my portion of the December 2024 episode, I will, of course, talk about a case law update. Today, I'll be discussing the unpublished opinion of Scott v. Ian Holdings, which was just issued on November 20th, 2024. Of note, the plaintiff's insurer was represented by my office on appeal. Now, ultimately, the Scott v. Ian Holdings case represents a third-party auto accident, but it talks about that tort recovery is limited to cases where the plaintiff suffers death, serious impairment of an important bodily function, or permanent disfigurement pursuant to MCL 500-3135, also known as the McCormick v. Carrier case. Now, as we all know, serious impairment of an important bodily function is an objectively manifested impairment of a serious important bodily function that affects a person's general ability to lead his or her normal life. Now, this inquiry is driven by specific facts and circumstances that are different in each case, which therefore requires plaintiff to offer evidence to satisfy each of those elements. Now, just a bit of background on this one. It seemed like a standard third-party auto negligence case, but the plaintiff here was stopped at a red light, struck by defendant's rental vehicle, and then filed suit against the at-fault driver, the rental company Ian Holdings, and who was represented by Secrest, Wardle, and sought to recover uninsured and underinsured motorist benefits. Now, plaintiff complained of injuries to her neck, back, shoulder, and knees, and following the accident, she sought medical treatment for those injuries. Now, here in the trial court, the defendants all moved for summary disposition, arguing in unison that plaintiff failed to establish that she sustained an injury, an objectively manifested injury, and that the accident or alleged injuries did not negatively impact her general ability to lead her normal life as required by McCormick v. Carrier. Now, while plaintiff did seek treatment from a variety of medical providers for her alleged injuries, by telling these providers that her pain and injuries were the result of an accident, nearly all of those providers opined that plaintiff's injuries were pre-existing, and therefore the trial court granted defendants' motions for summary disposition and dismissed plaintiff's suit. And then plaintiff appealed by right, which we have here. Now, on appeal, the Court of Appeals affirmed the trial court's granting of summary disposition, and the court's decision was largely based on plaintiff's failure to produce sufficient evidence to establish a threshold injury. Now, the panel properly observed the elements necessary to prove a serious impairment. As we all know, one, objectively manifested impairment of an important bodily function that affects a person's general ability to lead his or her everyday life. Now, here, the only evidence to suggest the impact of the accident on plaintiff's ability to lead her normal life was unsigned and an unsworn affidavit by plaintiff, and the Court of Appeals properly found that summary disposition was warranted because that was the only evidence to satisfy those elements. The doctor's visits and medical records did not satisfy the elements because, again, those doctors ultimately opined that all of her injuries were pre-existing, although she did refer to the subject accident as the cause of them. Her prior medical records and medical history proved otherwise. Now, while plaintiff's affidavit did attempt to offer into evidence that she was in good health prior to the accident, and that the accident resulted in her general inability to lead her life, the defects in the affidavit rendered it defective. Here, the affidavit was digitally signed, unnotarized, and undated. Accordingly, the affidavit could not be considered to establish a genuine issue of material fact as to the injuries plaintiff suffered, and the Court of Appeals further observed that on appeal, if plaintiff was to provide a new affidavit curing those deficiencies, it wouldn't be enough. The court correctly noted that that was an improper attempt to expand the record on appeal, and what was on the record at the time the trial court decided this issue was incredibly deficient. Now, this decision, while unpublished, ultimately shows that the absence of evidence showing an injury that affects a person's ability to lead his or her normal life is important to know in the very beginning of a case. A plaintiff cannot now offer evidence after summary disposition has been granted and try to expound upon the prior trial court hearing or trial court order. Now here, ultimately, the Court of Appeals affirmed the granting of summary disposition in this third-party negligent case, but it's important to note this in all cases such as PIP cases. Now, the only evidence to suggest that the impact of the accident on the ability to lead her normal life was an unsworn and unsigned affidavit, summary disposition was proper. And that is all I have for you guys today on the issue of updated case law. I'm going to now move on to trending topics in PIP litigation, which will be discussed by my partner, Jeff Buller.
Hello, everyone. My name is Jeff Buller, Jr. I am a C-level partner here at Secrest Wardle. I'm here to talk about the trending topics in PIP litigation. And one of these trending topics is lack of supervision in controversial laser treatment. Recently, medical providers in the no-fault world have been seeking reimbursement for charges related to a high-power, high-dose laser treatment rendered to accident victims. This high-power, high-dose laser treatment is marketed as an alternative to injections, physical therapy, and surgery. It utilizes laser light to increase blood flow, reduce inflammation, facilitate the removal of toxins from within cells, and encourages cell regeneration. The thing with this high-power, high-dose laser treatment is that only licensed physicians can perform it. Presents a roadblock for the small-time medical providers that plague Michigan's no-fault systems to render this kind of treatment. In 2005, the Michigan Department of Licensing and Regulatory Affairs, or LARA, issued a position statement titled Use of Laser Equipment by Health Professionals, which earmarked laser use as the practice of medicine. Further, LARA's position statement prescribed regulations that must be adhered to related to the use of laser equipment by health professionals. In May of 2024, the Federation of State Medical Boards released a comprehensive board-by-board overview of laser regulations for each state. This report confirmed that the use of lasers in Michigan by health professionals is governed by the 2005 position statement issued by LARA and notes that MCL 333.16215 governs the act delegation for the practice of medicine within Michigan. MCL 33.17001-1J, the practice of medicine, is defined as, and I quote, the diagnosis, treatment, prevention, cure, or relieving of a human disease, ailment, defect, complaint, or other physical or mental condition by attendance, advice, device, diagnostic test, or other means, or offering, undertaking, attempting to do, or holding oneself out as able to do any of these acts. Generally, the practice of medicine or the administering of medical treatment can only be lawfully performed by licensed physicians. This is per MCL 33.16294. Therefore, this laser treatment can only be performed by licensed physicians. Basically, an example is not physical therapists. However, based on LARA's position statement, a physician-dentist may delegate the use of laser equipment to a licensed or unlicensed individual only if the delegated individual works under the physician's/dentist's supervision. Delegation is defined by MCL 33.161042 as authorization granted by a licensee to a licensed or unlicensed individual to perform selected acts, tasks, or functions that fall within the scope of practice of the delegator and that are not within the scope of practice of the delegatee, and that, in the absence of the authorization, would constitute illegal practice of a licensed profession. The Public Health Code governing delegation, and utilized by the Federation of State Medical Boards in their May 2024 report, is MCL 33.162151 and reads, in pertinent part, a licensee who holds a license other than a health profession subfield license may delegate to a licensed or unlicensed individual who is otherwise qualified by education, training, or experience the performance of selected acts, tasks, or functions where the acts, tasks, or functions fall within the scope of practice of the licensee's profession and will be performed under the licensee's supervision. A licensee shall not delegate an act, task, or function under this section if the act, task, or function under standards of acceptable and prevailing practice requires the level of education, skill, and judgment required of the licensee under this article. Applying the previously discussed Public Health Code excerpt, a licensed physician, such as an MD, would be responsible for supervision of the laser treatments provided and billed for by these no-fault providers. Under MCL 33.161092, supervision is defined as otherwise provided in this article, which means the overseeing of or participation in the work of another individual by a health professional licensed under this article in circumstances where at least all of the following conditions exist. So everything that I'm about to discuss must exist. A, the continuous availability of direct communication in person or by radio, telephone, or telecommunication between the supervised individual and a licensed health professional. B, the availability of a licensed health professional on a regularly scheduled basis to review the practice of the supervised individual, to provide consultation to the supervised individual, to review records, and to further educate the supervised individual on the performance of the individual's functions. And C, the provision by the licensed supervising health professional of predetermined procedures and drug protocol. LAR's 2005 position statement provides a specific definition for supervision as it relates to laser use by medical professionals, which requires at least one of the following. A, acknowledgement by the physician dentist that the delegated individual has the appropriate education, training, or experience to properly use lasers. B, continuous availability of direct communication in person or by radio, telephone, or other telecommunication between the physician/dentist and the delegated individual. Regularly scheduled availability of the physician/dentist to consult, educate, and review the records and practice of the delegated individual in laser use. And D, development by the physician of written procedures and protocols to guide the delegated individual's laser use. Therefore, applying the above language, a licensed physician must supervise a non-licensed individual's use of the laser treatment in the event a non-licensed individual administers laser treatment. Despite the clear and unambiguous language of MCL 33.16104, MCL 33.162151, and MCL 33.16109, as I previously discussed, no-fault medical providers, they've been having unlicensed, unsupervised employees administer the laser treatment to their patients. In fact, our office recently deposed a physician from one of these medical providers who was identified as the medical director and supervisor of the laser treatment at this office. This doctor testified as follows. He never witnessed any of the medical provider's employees treat patients. He did not supervise any of the employees at this medical provider relative to the laser treatment. His staff did not tell him anything about the laser therapy treatment being conducted. He has not been trained on how to use the laser, and he does not know what kind of laser this medical provider uses despite being labeled as the medical director. Based upon this testimony from this medical professional, who's labeled as the medical director, it is evident that this medical provider attempted to put this physician in as the quote-unquote medical director position in a half-hearted attempt to make the laser treatments being rendered to their patients appear lawfully rendered. However, this provider did not even attempt to integrate this physician, this doctor, into the treatment of their patients. He was not given access to the medical records, and to his own admission, this medical provider never contacted him with any medical questions or any other general treatment concerns. MCL 33.162151 indicates that a licensee, such as this physician who we got this testimony from, is only authorized to delegate an act, task, or function if same under standards of acceptable and prevailing practice, requires the level of education, skill, and judgment required of the licensee, and since this medical professional, this doctor, has never utilized laser treatments in his own practice, he is not authorized to delegate this task to other individuals. Secrest, Wardle, our office, has been filing motions for summary decision based on medical providers' failures to have proper supervision of their laser treatment. While still early on, we have been quite successful on a few of these MSDs thus far and plan to file many more.
And that's all we have for you guys today. Thanks for attending the December 2024 episode of My PIP Monthly. Please feel free to contact myself or Jeff for any questions or concerns you may have. Our email and contact information are listed at the last slide of today's presentation.